Hello friends, I am Dr. Dharmendra Jain, Assistant Professor at the Department of Pharmaceutical Sciences, Dr. Hari Singh Gaur Central University, Sagar, Madhya Pradesh. Today we are going to learn about MRTP Act, that means Monopolies and Restrictive Trade Practices Act, from your B.Pharma 7th semester topic. This episode will help you to understand the basic concepts of the Monopolies and Restrictive Trade Practices Act by giving in-depth knowledge of the subject. So let's have a general introduction about the MRTP Act and what we are going to learn in this informative episode. Module 1. Introduction to MRTP Act. What is MRTP Act? Here is our first module in which we will deal with basics about MRTP Act. The MRTP Act of 1969 is an important piece of socio-economic legislation. It has a significant impact on the industrial structure and marketing practices of the business firms in India. Though the Act is relatively a small enactment, yet it is considered to be a complex one and has far-reaching consequences from the firms. Objectives of the Act. The principal objectives of the Act were: first, prevention of concentration of economic power to the common detriment; second, for the control of monopolies; third, for the prohibition of monopolistic and restrictive trade practices. After the amendment of the Act in 1984, a fourth objective was introduced, which was regulation of unfair trade practices. The MRTP Act extends to whole of India except Jammu and Kashmir. Provisions of the Act. The main provisions of the MRTP Act are: first, regulating expansions, mergers and amalgamations, and appointment of directors in respect of dominant undertakings having assets of rupees 1 crore and more, and of undertaking which by themselves or with interconnected undertakings have assets of not less than rupees 20 crores in value. Second, regulating the standing of new undertakings which would become interconnected undertakings of such existing undertakings, the total assets of which exceeds rupees 20 crores. Third, control over and prohibition of monopolistic and restricted trade practices as are found to be prejudicial to public interest. Now, non-applicability of MRTP Act. The MRTP Act 1969 provides that unless the central government by notification otherwise directs, this Act shall not apply to a. any undertaking owned or controlled by the government company; b. any undertaking owned or controlled by government; c. any undertaking owned or controlled by a corporation not being a company established by or under any central, provincial or state act; d. any trade union or other association of workmen or employees formed for their own reasonable protection as such workmen or employees; e. any undertaking engaged in an industry the management of which has been taken over by any person or body of persons in pursuance of any authorization made by the central government under any law for the time being in force; f. any undertaking owned by a cooperative society formed and registered under any central, provincial or state act relating to the cooperative societies; g. any financial institutions. Now, the Act assumes paramount importance in the areas of product, pricing, promotional and distribution channels from the marketer's point of view. Current status of MRTP Act. This act is not in force in India currently, as it was replaced by Competition Act 2002 with effect from September 1, 2009. The MRTP Commission was replaced by Competition Commission of India. Module 2. Monopolistic trade practices. A monopolistic trade practice is one which has or is likely to have the effect of 1. Maintaining the prices of goods or charges for the services at an unreasonable level by limiting, reducing or otherwise controlling the production, supply or distribution of the goods or services. 2. Unreasonably preventing or lessening competition in the production, supply or distribution of any goods or services. 3. Limiting technical development or capital investment to the common detriment. 4th. Deteriorating the quality of any goods produced, supplied or distributed. And 5th. Increasing unreasonably a. the cost of production of any good, or b. the charges for provision or maintenance of any services, or c. the prices for sale or resale of goods, or d. the profits derived from the production, supply or distribution of any goods or services. A monopolistic trade practice is deemed to be prejudicial to the public interest unless it is expressly authorized under any law or the central government permits to carry on any such practice. Firms involved in monopolistic trade practice tries to eliminate competition from the market. Enquiry into monopolistic trade practices. The Commission may inquire into any monopolistic trade practice 1. Upon a reference made to it by the central government, or 2nd. Upon an application made to it by the Director General, or 3rd. Upon its own knowledge or information. Reliefs available. First, where the inquiry by the Commission reveals that the trade practice inquired into operates or is likely to operate against public interest, the central government may pass such orders as it thinks fit to remedy or prevent any mischief resulting from such trade practice. Second, on an inquiry report of the Commission, the central government may a. prohibit the owners of the concerned undertakings from continuing to indulge in a monopolistic trade practice, or b. prohibit the owner of any class of undertakings or undertakings generally from continuing to indulge in any monopolistic trade practice in relation to the goods or services. Third, the central government may also make an order a. regulating the production, storage, supply, distribution or control of any goods or services by an undertaking and fixing the terms of their sale, including prices or supply. b. prohibit any act or practice or commercial policy which prevents or lessens competition in the production, storage, supply or distribution of any goods or services. c. fixing standards for the goods used or produced by an undertaking. d. declaring unlawful the making or carrying out of a specified agreement. e. requiring any party to the specified agreement to determine the agreement within the specified time, either wholly or to specified extent. f. regulating the profits which may be derived from the production, storage, supply, distribution or control of any goods or services, or g. regulating the quality of any goods or services so that their standard does not deteriorate. Module 3. Restricted trade practices. To maximize profit and market power, traders often attempt to indulge in certain trade practices which tend to obstruct the flow of capital into the stream of production. It may also bring manipulation of prices or conditions of delivery or affect the flow of supplies in the market so as to impose unjustified costs. Enquiry into restricted trade practices. The Commission may inquire into any restricted trade practice. First, upon receiving a complaint from any trade association, consumer or a registered consumer association, or second, upon a reference made to it by the central or state government, or third, upon its own knowledge or information. Relief available. The Commission shall, if after making an inquiry, it is of the opinion that the practice is prejudicial to the public interest or to the interest of any consumer, it may direct that first, the practice shall be discontinued or shall not be repeated. Second, the agreement relating thereto shall be void in respect of such restricted trade practice or shall stand modified. Third, the Commission may permit the party to any restricted trade practice to take steps so that it is no longer prejudicial to the public interest. However, no order shall be made in respect of first, any agreement between buyers relating to the goods which are bought by the buyers for consumption and not for ultimate resale. Second, a trade practice which is expressly authorized by any law in force. Module 4. Unfair trade practices. Unfair trade practices means a trade practice which, for the purpose of promoting the sale, use or supply of any goods or for the provision of any services, adopts any unfair or deceptive practice, including any of the following practices: A. Misleading advertisement and false representation. B. Falsely representing that goods and services are of a particular standard, quality, grade, composition or style. C. Falsely representing any second-hand, renovated or old goods as new. D. Representing that goods or services seller or supplier have a sponsorship, approval or affiliation which they do not have. E. Making a false or misleading representation concerning need for or usefulness of goods or services. F. Giving to public any guarantee of performance that is not based on an adequate test or making to public a representation which purports to be such a guarantee or warranty. F. False and misleading claims with respect to the price of goods or services. H. Giving false or misleading facts disparaging the goods, services or trade of another person or concern. Enquiry into unfair trade practices. The Commission may inquire into any unfair trade practice. First, upon receiving a complaint from any trade association, consumer or a registered consumer association, or second, upon reference made to it by the central government or state government. Third, upon an application to it by the Director General, or fourth, upon its own knowledge or information. Relief available. After making an inquiry into the unfair trade practices, if the Commission is of the opinion that the practice is prejudicial to the public interest or to the interest of any consumer, it may direct that first, the practice shall be discontinued or shall not be repeated. Second, the agreement relating thereto shall be void in respect of such unfair trade practice or shall stand modified. Third, any information, statement or advertisement relating to such unfair trade practice shall be disclosed, issued, published as may be specified. Fourth, the Commission may permit the party to carry on any trade practice to take a step to ensure that it is no longer prejudicial to the public interest or to the interest of the consumer. However, no order shall be made in respect a trade practice which is expressly authorized by any law in force. The Commission is empowered to direct publication of corrective advertisement and disclosure of additional information while passing orders relating to unfair trade practices. What is MRTP company? The firms with assets of rupees 25 crores or more were put under the obligation of taking permission from the Government of India, and they were called MRTP companies. This upper limit of rupees 25 crore was known as MRTP limit. It was later relaxed to rupees 50 crores in 1980, rupees 100 crores in 1985, and in 1991 this limit was removed. Now only companies having more than 25% market share were called monopolies. Module 5. MRTP Commission. For the purpose of this Act, the central government has established a commission to be known as Monopolies and Restricted Trade Practices Commission. The MRTP Commission was set up under Section 5 of the Monopolies and Restricted Trade Practices Act 1969. The MRTPC is an organ of Department of Company Affairs, Ministry of Company Affairs, Government of India. This commission shall consist of a chairman and minimum 2 and maximum 8 other members, all to be appointed by the central government. Every member shall hold the office for a period specified by the central government. This period shall not exceed 5 years. However, the members will be eligible for reappointment. The chairman of the commission shall be a person who is or has been or is qualified to be a judge of the Supreme Court or of a High Court, and the members thereof shall be persons of ability, integrity, and standing, who have adequate knowledge or experience of or have shown capacity in dealing with problems relating to economics, law, commerce, accountancy, industry, public affairs, or administration. Before appointing any person as a member of the commission, the central government shall satisfy itself that the person does not and will not have any such financial or other interest as is likely to affect prejudicially his functions as such member. A. MRTPC was a quasi-judicial body. B. Major functions of the MRTP Commission is to inquire into and take appropriate action in respect of unfair trade practices and restricted trade practices. C. In regard to monopolistic trade practices, the Commission is empowered to inquire into such practices. D. Upon a reference made to it by the central government. E. Upon its own knowledge or information and submit its findings to the central government for further action. Powers of Commission. The MRTP Commission has the following powers. First, power of civil court under the Code of Civil Procedure with respect to A. Summoning and enforcing the attendance of any witness and examining him on oath. B. Discovery and production of any document or other material object producible as evidence. C. Reception of evidence on affidavits. D. Requisition of any public record from any court or office. E. Issuing any commission for examination of witness. And F. Appearance of parties and consequences of non-appearance. Second, proceedings before the Commission are deemed as judicial proceedings within the meaning of sections 193 and 228 of Indian Penal Code. Third, to require any person to produce before it and to examine and keep any books of accounts or other documents relating to the trade practice in its custody. Fourth, to require any persons to furnish such information as respects the trade practice as may be required or such other information as may be in his possession in relation to the trade carried on by any other person. Fifth, to authorize any of its officers to enter and search any undertaking or seize any books or papers relating to an undertaking in relation to which the inquiry is being made if the Commission suspects that such books or papers are being or may be destroyed, mutilated, altered, falsified, or secreted. Filings of complaint. In case of any unfair trade practice, monopolistic trade practice and/or restricted trade practice, a complaint can be filed against such practices to the MRTP Commission. The procedure for filing a complaint is as follows. First, complaint is filed either by the individual consumer or through a registered consumer organization. Second, the Director General of MRTP Commission would carry on the investigation for finding facts of the case so as to satisfy itself that the complaint is genuine and deserves to be inquired into. Third, if the prima facie case is not made, the complaint is dismissed. If the complaint is true, an order is passed to its effect. Fourth, the Commission restricts and restrains the concerned party from carrying on such practices by granting temporary injunction. Fifth, then the final order is passed. The complainant may be compensated for his loss. Sixth, complaints regarding monopolistic trade practice, unfair trade practice and restricted trade practice can be made to the MRTP Commission at the following address: Director General Investigation and Registration, MRTPC, Bikaner House, Barracks, Shahjahan Road, New Delhi 110011. Telephone number 011-233-85961 or 011-233-85970. Fax number 011-233-84965. Remedies under the Act. Under the Monopolistic and Restricted Trade Practices Act 1969, the Commission has the power to attend complaints, inquire facts and pass orders regarding any unfair trade practice, monopolistic trade practice and/or restricted trade practice. The Commission can order any person to bring in any books of accounts or other documents to investigate the matter of such practices. During investigation, if the Commission has grounds to believe that any books or papers are being destroyed, mutilated, altered, falsified or secreted, it may authorize any officer of the Commission to search and seizure any such books or papers. The Commission, after inquiring the case, shall pass the remedial order. The remedies under the Act are temporary injunction and compensation. Section 12A. Power of the Commission to grant temporary injunctions. Section 12A of the MRTP Act 1969 accounts for the power of the Commission to grant temporary injunctions. The provisions of the section are: first, where it is proved that any undertaking or any person is carrying on any monopolistic or restricted or unfair trade practice, and such monopolistic or restrictive or unfair trade practice is likely to affect the interest of any trader, class of traders or any consumer or public generally, the Commission may, for the purpose of staying or preventing the undertaking, grant a temporary injunction restraining such undertaking or person from carrying on any monopolistic or restricted or unfair trade practice until the conclusion of such inquiry or until further orders. Second, for the purpose of this section, an inquiry shall be deemed to have commenced upon the receipt of any complaint or reference by the Commission or upon its own knowledge or information reduced to writing by the Commission. Third, for the removal of doubts, the power of the Commission with respect to temporary injunction includes power to grant a temporary injunction without giving notice to the opposite party. Fourth, provisions of the rules shall apply to a temporary injunction issued by the Commission under this section as they apply to a temporary injunction issued by a civil court, and any reference in any such rule to a suit shall be construed as a reference to an inquiry before the Commission. Section 12B. Powers of the Commission to award compensation. Section 12B provides for the second remedy under this Act. This provision regarding the power of the Commission to award compensation is: first, where any loss or damage is caused to the central government or state government or traders or class of traders or any consumer because of the monopolistic or restrictive or unfair trade practice carried on by any undertaking or any person, then such government, trader, class of traders or consumer may make an application to the Commission for the recovery of any compensation from that undertaking or a person. The recovery shall be of such amount as the Commission may determine as compensation for the loss or damage so caused. Second, where any loss or damage is caused to numerous persons having the same interest, then one or more of such persons may, with the permission of the Commission, make an application for the benefit of all the persons so interested. Third, the Commission, after inquiring into the allegations made in the application, shall make an order directing the owner of the undertaking to make payment to the applicant of the amount determined by it as realizable from the undertaking as compensation for the loss or damage caused to the applicant by reason of any monopolistic or restrictive or unfair trade practice carried on by such undertaking or other person. Fourth, where a decree for the recovery of any amount as compensation for any loss or damage has been passed by any court in favor of any, the amount shall be set off against the amount payable under such decree. Every order made by the Commission under Section 12A granting a temporary injunction or under Section 12B awarding compensation may be enforced by the Commission in the same manner as if it were a decree or order made by a court. In case such orders are not executed by the undertaking or other person, then it shall be lawful for the Commission to send such order to the court. Drawbacks of MRTP Act. Following are some of the drawbacks of MRTP Act. First, poorly resourced Commission. Second, inadequacy in dealing effectively with anti-competitive practices due to lack of definitions, cumbersome procedures and scarce resources. Third, absence of specification of identifiable anti-competition practices. Fourth, anti-competition practices like cartels, predatory pricing, rigging, etc. are not specifically mentioned in the MRTP Act. Module 6. Conclusion. At the time of drafting of the MRTP Act, the economic and trade milieu prevalent at that time constituted in India only for its various provisions. However, ever since, there has been considerable movement towards liberalization, privatization and globalization. That means the new economic policy 1991. Hence, the law needed to yield to the changing scenario on both the economic and trade fronts. It can be said that the MRTP Act was successful to an extent. However, due to scarcity of resources, lack of clearly defined procedures and cumbersome rules and regulations, the Act was not as effective as it was supposed to be. Also, the changing economic and trade environment brought by the new economic policy 1991 made it necessary for a change in the MRTP Act. Hope it was quite interesting learning session. I will meet you again with other interesting episodes in coming days. But if you want to know more and learn, you may visit to our website cec.nic.in for more interesting facts, lectures, quizzes, frequently asked questions and many more.